afternoon. Welcome to Jones Keller. I'm Nicole Westbrook. I'm a commercial trial attorney in Denver, Colorado, and joining me today is Spencer Reese from the law firm of Reese Richards in Utah. We'll be discussing a couple of matters pertinent to network marketing companies today and their independent distributors, including significant proposed rules at the Federal Trade Commission level, as well as non-compete clauses. Welcome, Spencer. So you and I were talking not too long ago about some exciting new rulings on the horizon at the FTC that might impact network marketing companies.
Well, yeah, that's right. I mean, we have a proposed notice of rulemaking in which let me back up. Last June, the FTC lost its authority under Section 13B of the Federal Trade Commission Act. That was the section of the statute that they had traditionally used to get injunctive relief against bad people they deemed bad apples. The problem was, of course, that it really denied due process, any form of due process to the defendants. So the Supreme Court, in a ruling last June, stripped them of that authority. To rebut that ruling is they have been seeking other ways to pursue actions, adverse claims or adverse earnings claims, or what they view as deceptive earnings claims against network marketing companies. They have taken two steps to do that. First is they have relied on their penalty offense authority, which is something they've had for a long time. The other is that they have issued a proposed notice of rulemaking. They did this in March. They want to issue a rule on what is going to be a deceptive earnings claim. By doing so, they will be entitled to automatic damages. All they need to show is that somebody has made a deceptive earnings claim, which is frankly a slam dunk case compared to a pyramid case. Or the FTC is trying to get a ruling as far as what is a deceptive earnings claim. So that's where we stand right now. I don't know. I do know that we will see a rule at some point. I don't know when that ruling is going to be issued. I suspect it could take years.
And of course, Spencer, you and I have seen before a number of times these different multi-level or network marketing companies. They typically have in their rules or regulations, in their policies, they have deceptive income earning claims, correct?
They do prohibit deceptive earnings claims, but again, the trouble is, first off, a company will issue a 40-page manual, for example. Is it reasonable to expect someone to actually read through all that? Of course not. Do they know that people don't read it? Of course they know that. And secondly is trying to understand what is going to be viewed as a deceptive earnings claim or income claim. That's a tricky subject, and the policies may spend 2 paragraphs on it at most. Trying to explain what is a deceptive earnings claim or income claim in 2 paragraphs, even if it were to be read, is nigh on impossible.
And so as the FTC ramps up pressure on the network marketing companies, certainly you can see the network marketing companies starting to ramp up that same amount of pressure on their distributors. What do you think distributors can do kind of looking forward to stay safe from these policies that maybe aren't that well written for deceptive income claims?
Well, what a distributor needs to do is stick to using the income disclosure statement that is issued by the company. I mean, the income disclosure statement typically has the information that is necessary to make what could potentially be a deceptive claim, essentially to fix it. And that is really my recommendation. Now, a lot of times companies will play a game of hide the ball when it comes to publishing their income disclosure statements, but there's no way that a distributor is going to really know that. They don't know that they're trying to get the information necessary to make a proper disclosure. It's just not something that a distributor has the wherewithal to do. They don't have the information. But the best they can do is rely on the published information, the published income disclosure statement issued by the company.
And you and I both coordinate with or counsel with different network marketing companies as well. And as we know, they always want to avoid any review by the FTC. And so as they're moving forward and maybe writing new policies and procedures procedures for their distributors. What can the network marketing companies be doing to look forward of what the FTC is going to pass and maybe start massaging or changing these policies to better protect the company from the FTC?
Well, what we have is a situation where we are going to see a ruling essentially shoved down the throats of network marketing companies. Because network marketing companies have, and distributors too, have continue to fail to provide adequate disclaimers and disclosures about what is a proper income claim, we can expect to have these things shoved down our throats, these regulations shoved down our throats. That's going to happen, in my opinion. Now, what can a company do to adhere or to best protect itself? Well, that is promote transparency of their income opportunity. And really that means providing an honest and open and a transparent income disclosure statement. Don't play a game of hide the ball with it. Be very frank about what your income opportunity provides or offers. The reality is that most distributors don't earn very much money, if any at all. And that is going to be a critically important disclosure in any income disclosure statement.
And Spencer Reese and Reese Richards both work really hard to draft a lot of these contracts for network marketing companies. And on my side at Jones Keller, we work really hard to litigate and defend a lot of these FTC actions and other regulatory or distributor actions. They're all very costly. I think, Spencer, if we're being honest, the way to go is the pound of prevention. Don't you agree?
Oh, absolutely. These cases, I mean, the reality is that when you're fighting against the FTC, you may win a battle or two, but you will lose the war as soon as they file a complaint. I mean, that's the unfortunate reality. Well, this is really the where I foresee the future of FTC enforcement is going. It's really something that a company needs to get out in front of. And to do so, they need to review their income disclosure statements, because we know distributors are going to make income claims. That's what they've done forever. And despite what you say, any prohibitions in the company's policies, they're going to do it. I mean, that's the reality. I mean, it's unfortunate, but you can tell somebody not to do something, but if you're paying them to do the opposite, well, guess what they're going to do? They're going to do what they're paid to do, not what they're told to do. Duh. So the best that a company can do is get out in front of it with an income disclosure, with a good income disclosure statement, a really transparent one.
So another area that you and I cross paths with quite a bit is this non-solicitation or non-compete. When a distributor leaves the first multi-level marketing company and they join the second network marketing company, oftentimes that's a big problem, but yet it's very common as well to move from place to place. And so what's happening right now with the non-solicitation and non-compete provisions that we're seeing in the law?
Well, what the issue has become, it used to be pretty easy to deal with one of these cases. You'd get your evidence, and that would come in the form of some sort of correspondence, or once the internet came around, an email or something to that effect, where somebody was it was relatively easy to pick out a solicitation. That has all changed since social media has taken over. I mean, social media is where it's at anymore, and that's how distributors communicate, and it's so easy. But what it has become is a much more subtle form of recruiting, much more subtle than it used to be. Anymore, that somebody will post up on their social media page what is seemingly a very innocuous, in fact, a very complimentary post about their prior company, saying, "Oh, I had a great run with company XYZ, or its products are wonderful. I will always use them, blah, blah, blah. But I am moving on to my next project or my next deal." And so what they are doing is very subtly inviting someone to contact them so that they can say, "Oh, I didn't reach out, or I didn't violate my non-solicitation. They contacted me. I just responded to their inquiry." Well, let's not play games here. We know full well what's going on. And that is, it's turned into this very subtle form of solicitation. And that is, in fact, going to be a violation of a non-solicitation policy if the company's policies specify that it constitutes a violation. I mean,
and that's the expensive part, Spencer, right? Ambiguity in any contract, but certainly in these distributor contracts, that's always where you get into litigation. The more open for interpretation, the more likely you're going to go to court, the more likely it's going to go to trial, and that's what makes things really expensive. But what I think is so interesting is how many distributors get caught up and confused by this, because you have a social media presence and it's your own probably, or you walked into a company X, as you said, with your own presence and your own social media, and this downline of followers on Twitter or on Facebook. These are your family members, these are your coworkers at the office, these are your friends since you were little kids, people that you're keeping in touch with. But as you say, even though these are your people, these are your family, if you're kind of flying too close to the sun and really talking to them about your former opportunity and then possibly saying, and now I'm going to company Y, you're going to get burned.
And what it has become, as I mentioned, is this subtle form of recruiting. But I mean, the question is, who owns these databases that are created that are pre-exist somebody's enrollment in a network marketing company? I mean, of course, a distributor is going to take the position that, well, no, I've got. Of course, I recruited my friends, and that's what they're supposed to do. I mean, that's what the company wants them to do. And so the question is, but do they automatically become the company's property as soon as they pitch them on the company X's program? Well, according to the policies, yes, they do. And it's become a database that pre-existed somebody's enrollment in a network marketing company, and but it is also something that the company lays claim to, because of course, if somebody's going to pitch their opportunity or their program on their social media pages, and so what are they doing? Is somebody really gaining an advantage or using the company, riding its coattails, so to speak? Is somebody riding the company's coattails to gather people to solicit or to recruit? Or are they simply, talking to their downlines and talking to their friends and using their social media page as it is intended? I mean, that's become a big issue, and that's an issue, Nicole, that you're going to be litigating for sure.
And perhaps hand in glove with that, Spencer, is this idea of the non-compete. And typically non-compete clauses have to be narrowly tailored to a certain amount of time and sometimes a certain geographical area. So you can't just prevent someone from working for the rest of their lives if they leave a company. But the question is, how long do you have to wait until you start activity again? And how long, or what might be the new geographical area where you're limited to? Or might it be a certain type of product or a certain type of company? And so you need to look also through your policies and the rules that govern you to see when is that cutoff point from the time that you leave until the time that you can start again.
That's the provision that causes more anguish and angst between companies and distributors, more so than all other policies combined. It's a huge, huge issue, and it's not going away. It's been around forever, and it will continue to be around forever. It morphs, but as technology progresses, we have seen and will continue to see how differing interpretations and applications by the courts and how these things are going to be treated. I just know that we need to get out in front of them when we're dealing with policies and have to write the rules so that we at least have something to talk about. Because, just because one court rules one way doesn't mean another court's going to follow it or is going to agree. You could have differing opinions on the same rule by different courts. It happens, and that's reality.
Too often, Spencer. So thank you, Spencer, for being with me today and for talking to us about the new potential FTC rulings, non-solicitation, non-compete clauses. Spencer Reese at Reese Richards in Utah, and I'm Nicole Westbrook at Jones Keller in Denver, Colorado, and look forward to the next time we get to chat and work together, Spencer. I think we've been working together for some 15 years now, if you can believe it. We'll see you on the next series. Thank you so much.